while we were in chambers, juror number 15 was excused for legal reasons. We were in court last week and had resolved jury instructions. After that time, each counsel had contacted the court and each other about suggested changes that should be made to what had been thought to be the final jury instructions. Mr. Merrings, you go first.
Court, after we left on Friday, was including in count 2 of the jury instructions that the two-part basically put it as a personal application of physical or cause. On Saturday, we reviewed the indictment and found that the indictment only charged first, and therefore I said in my emails to court counsel, well, opposing counsel, that the second part of the assault instruction should be deleted as it was not covered by the indictment, which was not the second thing.
Mr. Martinez, what's your position on that request?
I don't have anything to add.
Because of the case that had been discussed during the jury instructions, the court agreed to make the change, and so under count 2, the jury will be instructed only on the reasonable apprehension theory of aggravated assault. And then, Mr. Martinez, you had a suggestion with respect to giving the jurors 404 and 405 self-defense instructions.
At the time that the defendant claims that he was placed in a situation where self-defense would have been appropriate, he was not acting as a police officer. At that point, he was not attempting to effect an arrest or any duty that involved a police officer at that time. He was, according to him, fearing for his life. So I asked that the general instruction on self-defense be given.
Mr. Marin. All right. In discussing the instructions last week, it was noted that there was a distinction between 404, 405 self-defense and 408, 409 self-defense, in that in general self-defense, it is a key point who the aggressor is. With respect to police officers, they are entitled to initiate conduct under certain circumstances, which is covered by their specific instructions regarding self-defense in a law enforcement context. So the court had originally deleted 404 and 405 from the instructions. That language originally was approved. Mr. Martinez's objection, I still think, is timely, but overruled on the grounds that the instructions are covered under the law enforcement status of Mr. Chrisman at the time of the incident. Anything else before the jurors come in, Mr. Martinez?
No.
Mr. Merritt? What's not working? You guys, if you could spread out, apparently you can't be blocking the doors. The fire marshal will lock us up, send us away. Yes. Sam? You are intern, so you can sit up here and save somebody, open up a chair for somebody. That'd be fine. Martinez, is it okay to do yours in 2 units, or you just want to do it all after lunch, and we'll take an early lunch?
I don't mind starting now.
Okay. Record should reflect the presence of Mr. Chrisman, counsel, and the jurors. Good morning. We have a legal issue with respect to Juror 15, so Juror 15 was excused, but we'll resume with the trial. Each of you should have a copy of the instructions. I'm going to read them. You are welcome to follow along. It is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel that I have about the facts. You as the jurors are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction and part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. In their opening statements and closing arguments, the lawyers have talked to you and will talk to you about the law and the evidence. What the lawyers said and will say is not evidence, but it may help you understand the law and the evidence. During the trial, the lawyers are permitted to stipulate that certain facts exist. That certain evidence exists. This means that both sides agree that evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. You are to treat stipulations as any other evidence. You are free to accept it or reject it in whole or in part, just as any other evidence. You must decide whether the defendant is guilty or not guilty by determining what the facts in the case are and apply these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. You are to determine what the facts in the case are from the evidence produced here in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise observed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless whether it is direct or circumstantial. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the test for truthfulness that people use in determining matters of importance in their everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all the evidence in the case in the light of reason, common sense, and experience. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You ought to consider the testimony of a police officer just as you would the testimony of any other witness. You must evaluate the defendant's testimony the same as any witness's testimony. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. The law does not require any defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced the defendant is guilty of any crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. The defendant is charged with second-degree murder, aggravated assault, and cruelty to animals. The charge is not evidence against the defendant. You must not think the defendant is guilty just because of the charge. The defendant has pled not guilty. The plea of not guilty means the state must prove every part of each charge beyond a reasonable doubt. Each count charges a separate and distinct offense. You must decide each count separately on the evidence with the law applicable to it, uninfluenced by your decision on any other count. You may find that the state has proved beyond a reasonable doubt all, some, or none of the charged offenses. Your finding for each count must be stated in a separate verdict. Count 1 charges the defendant with the crime of second-degree murder. The crime of second-degree murder requires the state to prove the following. The defendant, without premeditation, intentionally caused the death of another person, or the defendant, without premeditation, knowing that his conduct would cause death or serious physical injury, caused the death of another person. Count 2 charges the defendant with aggravated assault. The crime of aggravated assault requires the state to prove the following two things. The defendant intentionally put another person in reasonable apprehension of immediate physical injury, and the defendant used a handgun. Count 3 charges the defendant with cruelty to animals. The crime of cruelty to animals requires the state to prove that the defendant intentionally or knowingly killed a dog in the care and custody of another, and without legal privilege or consent of the owner. Intentionally means that the defendant's objective is to cause that result or engage in that conduct. Knowingly means that the defendant acted with awareness of or belief in the existence of conduct or circumstances constituting an offense. It does not mean the defendant must have known that the conduct was forbidden by law. If the state is required to prove the defendant acted knowingly, that requirement is satisfied if the state proves the defendant acted intentionally. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established by direct sensory proof. The existence of intent is one of the questions of fact for your determination. The defendant has raised the doctrine of self-defense. If evidence was presented that raises the defense of self-defense, then the state has the burden of proving beyond a reasonable doubt that the defendant did not act with such justification. If the state fails to carry this burden, you must then find the defendant not guilty of that charge. A police officer is justified in threatening or using physical force against another if in the making or attempting to make an arrest or detention, or in preventing or attempting to prevent an escape, such police officer uses or threatens to use physical force, and all of the following exist. A reasonable person would believe that such force is immediately necessary to effect the arrest or detention or prevent the escape. Such person makes known the purpose of the arrest or detention, or believes that it is otherwise known, or cannot be reasonably be made to be known to the person to be arrested or detained. A reasonable person would believe the arrest or detention to be lawful. police officer may threaten the use of physical force or deadly physical force only if a reasonable person effecting the arrest or preventing the escape would believe the suspect is actually resisting the discharge of a legal duty with physical force or with the apparent capacity to use deadly force. A police officer may use deadly force against another only when the police officer reasonably believes that it is necessary to defend himself or a third person from what the police officer reasonably believes to be the use of immediate use of deadly physical force, to effect an arrest or detention of a person whom the police officer reasonably believes has committed, attempted to commit, is committing, or attempting to commit a felony involving the use or a threatening use of a deadly weapon or dangerous instrument, is attempting to escape by use of a deadly weapon or dangerous instrument, through past or present conduct of the person which is known by the peace officer that the person is likely to endanger human life or inflict serious bodily injury to another unless apprehended without delay. A police officer is justified in threatening to use deadly force when and to the extent a reasonable officer believes it necessary to protect himself against another's potential use of deadly physical force. You must measure the defendant's belief against what a reasonable police officer would have believed. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under circumstances in which it is used, attempted to be used, or threatened to be used. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. It is lawful for police to enter a premise without a search warrant when they have permission to enter by a person whom they have reason to believe can give them consent to enter. If you find that the state has lost, destroyed, or failed to preserve evidence whose context or quality are important to the issues in this case, and that the explanation for the loss, destruction, or failure to preserve is inadequate, then you may assume that the evidence was unfavorable to the state. This fact may create a reasonable doubt about the defendant's guilt. The balance of the instructions I will give you at the end of the closing arguments by the attorneys. Mr. Martinez, you may proceed.
Good morning. My presentation to you today is going to be broken down into 3 parts. Initially, I'm going to talk to you about the facts. Actually, I'm going to talk to you about an execution where an individual, a human being, was killed by Richard Chrisman on October 5th, 2010. The second part of what I will speak to you about has to do with the jury instructions. The jury instructions are the law in the case. As they themselves indicate, those instructions are mandatory. They're not discretionary. Even though you may not agree with them, it is your duty to follow those jury instructions. And under those jury instructions, in this case, the defendant does not have self-defense available to him. The defendant or anybody cannot take a gun, point it at somebody, and then, as that person steps back, with no weapon or anything in their hand, shoot them to death. The jury instructions tell you that that self-defense is not available. Additionally, even though the defendant may have had a badge, even though he may have had a blue uniform, on each side of his shoulders he may have had a sign or an indication that he was with the Phoenix Police Department, yes, he may enter a home, but it does not give him a license to enter that home and immediately place a gun to anybody's head and put it there just to scare the dog. The jury instructions are clear that there is no such doctrine, there is no self-defense, and you've indicated that you would follow that. Lastly, I will address the defense that was presented for you here. And it really was a defense of faith. In other words, they wanted you to have faith. They wanted you to have faith in the defendant's words, even though science may not have agreed with him, even though the forensic research may not have agreed with him. They want you to believe the defendant. They want you to have faith in the face of scientific knowledge and forensic advances. Specifically, you know that there was a pattern, a stippling pattern on Daniel Rodriguez's chest. You know that? Yeah, now the defendant wants to tell you that there was something in between, a bicycle, and that this bicycle was in between him and Mr. Rodriguez, yet there's a pattern there. He wants you to believe that somehow this gunpowder was magic, that it missed everything of the bicycle, was able to go in between them, and then still make this pattern that you have been able to see. Additionally, he told you, or you've already also seen, and he wants you to disbelieve your own eyes. You've seen the blood that was at the scene. You've seen, as we stood in this particular area, Daniel Rodriguez, the victim, laid there. You saw the blood to the right of the box, and you saw, as far as the door here, the blood. The defendant indicated to you that that's where he was standing, in this particular area, at the time that he fired those fatal shots. But he wants you to believe that somehow he was standing in between the drops of blood, so that as he stood there, everything around him had blood on it, except the top of him, except the right leg, and only very small amounts on the left leg. It was that special kind of blood, or perhaps it was the special kind of heart beating that, for the defendant, it avoided. Perhaps it was worried about his cleaning bill on his uniform. The other thing that the defendant told you, and they stood right here, him and his counsel, as he came down here and demonstrated with the bicycle. He held it up. Of course, he has to hold it up because of the pattern that we have here. But he can't hold it high enough up because the bicycle is approximately 3 feet high. Held it up. As he held that bicycle up, he indicated how the victim, Mr. Rodriguez, was bending forward. And in fact, they brought in Vincent DeVaglio, the individual who could step into a class and bring in a cheat sheet and tell you what he heard in the class. You can read. You don't need him to tell you that. But of course, he was brought in because the first expert that they called somehow didn't fit the bill and indicate anything about any toxicity when it came to methamphetamine use. But they indicated to you, the defendant, as well as Mr. DeMaio, that the bicycle was up, leaning forward, and there was motion in that direction. And as already been indicated to you, a bullet does not stop motion. It kills people, but it doesn't stop motion. In this case, the defendant wants you to believe that motion can be stopped. He wants you to have faith in his word. You see, he forgot that if there were motion, that bicycle would have landed on him. Would have landed on his uniform, caused his, perhaps his pen to fall over, but he didn't tell you that. You see, with the truth, you have to remember nothing. And the defendant, when he took the stand, had a lot to remember. Can you almost blame him that he forgot about this issue, about the bicycle coming at him? And he forgot to tell you about that. And he forgot to tell you about that because that wasn't the truth. But he wants you to have faith. That's what he wants you to have. Well, that's not how you decide this case. You decide this on the facts, the evidence that was presented, not on faith. And you don't disregard the medical evidence, you don't disregard the forensic evidence, and you don't abdicate what you're on scene. For example, on that bicycle, when you take it back there to look at it, you'll be able to see not a single stippling item on it, not a single position where there's any stippling. You'll be able to see that. So let's talk about the defendant killing Daniel Rodriguez back on October 5th of 2010. This thing started, as it often does with these police things, when the police are called up, by a call. And there was a call to 911. The call was at 12:09 in the afternoon, mid-morning, actually. This call went out, and it was given a priority. It was given a priority 2. And that priority 2 means that they'll get to it as soon as possible. The defendant, of course, wants you to believe that there's a 5-minute requirement that they respond. And he wants to say that because he wants to cast aspersions early on Officer Sergio Virgil. He wants to say that this officer doesn't meet the grade. And so he indicates or includes a 5-minute response time. Of course, it's his word. Remember, he wants you to just have faith. Well, No one responds within 5 minutes. And you've seen the CAD printout, the computer-aided dispatch printout that indicates that the call came out and the person was complaining, Elvira Fernandez, was complaining about her son. He gave the name, the date of birth. One of the other things that she indicated was that he had thrown something against the wall. That was generally it. No indication of weapons, nothing like that. After Sergio Virgilio answered up, as he said, he made his way over to this mobile home park. Ms. Fernandez was at trailer number 50. And the reason she was at trailer number 50, according to their witness, Captain Black, was that she had come over to use the telephone. Not only did she call the police from her trailer, but she called the police at Ms. Black's insistence. Because, according to Ms. Black, perhaps tough love is what her son needed at this point. At that point, according to their own witness, Ms. Fernandez was not going to call the police in this situation. So she does do that. She makes the call. And after she makes the call, you're able to hear on the 911 tape what she sounded like, what her voice was like, whether or not you could understand her. You can rely on your ears, even though you were told by the defendant that she was hysterical. You listened to it. You were able to hear what she was able to say. You were able to hear how clear she was on that 911 call. Nothing excitable about it. Nobody can tell you what she sounded like. You have the recording that they made available. So they can't now turn around and say, well, no, don't listen to that recording. That recording is to be listened to, and you have the opportunity to do that, and you have done so on 2 separate occasions, during their opening statement as well as during the presentation of their case. And you can use your own ears, your own common sense, as the jury instructions tell you, to determine whether that person was hysterical or not, whether Elvira Fernandez in that telephone call was upset or hysterical. You can make that judgment for yourself. And so after Officer Virgilio answers up to the call, he begins to make his way there. And he begins to make his way, and at some point, there's another request to have another officer out there. And that's where the defendant becomes involved. He also answers up, and he makes his way over to the mobile home park. What he tells you is that he's on his way there, and he gets there before Officer Virgilio. He wants you to disbelieve the CAD printout. He wants you to disbelieve what the computer printout says, because it's him after all. He's the one that wants you to believe that. There's no indication anywhere that that printout is not reliable. But he says, oh, I was standing there, or waiting there in front of this mobile home park, and I was waiting there trying to get this computer to work, trying to get this map so that I could figure out where it was that I needed to go there. And while I was there, that's when Officer Virgilio arrived. But I actually was there first. I was the one that brought up the map. I was the one that knew exactly where this place was. Really? What did the photograph show you? The photograph showed you that the person who actually got there first was Officer Virgilio, not Richard Chrisman. But don't believe your eyes. Whatever you do, don't believe your eyes, because you know what? He took a wrong turn. He was following that silly old MapQuest, and that silly old MapQuest, well, you just can't really follow it according to him. And so he took a wrong turn, and guess what? All of a sudden, the photographs show something. They show the Tahoe in front, and they show the defendant's vehicle coming in afterwards. And so he wants you to disbelieve your eyes, disbelieve the photographs, disbelieve a CAD printout. He wants you to do that because, of course, Officer Virgilio, he's the person that should not be believed according to their view of things. But you have to have faith. And so, when they get there, Officer Virgilio is already out of the Tahoe. That's how quickly he got there before him. He's already out of the Tahoe. Officer Virgilio, who did check his taser, who did do the spark test, who is the conscientious officer that morning at 6 o'clock. He's the officer that's there already. He's the person that's already out of the truck. And how long did it take Officer Virgilio to get out of the truck? Well, it took him some time to collect his things, to get everything ready so that he could get out. In the meantime, the defendant wants you to believe that he's making circles somewhere, that he's taking a left where he should have taken a right and made the wrong turn somewhere else, even though he's following the map. But he forgot something. It's he and Officer Regillo are going at the same time. Why then is it that Officer Regillo had no problem going there, and the defendant who was following him did? Is it, as they want you to believe, that he's in front, and Officer Regillo chose to disregard where the defendant was going? No, he didn't testify to that. Or could it be that Officer Regillo was in front, and the defendant just wasn't paying attention? Just like it seems to be with him. Just doesn't seem to have the attention to detail that he should have, just like that taser that he didn't test. Well, he gets there. Guess what? Officer Regillo is already going to trailer number 50. He's so eager, he can't wait to get at it. He's so eager, he's such a neglectful officer that he forgets to bring the second cartridge to his taser. They brought in this apologist, Lon Bartel, their own witness, who said, well, yeah, you need to have a second cartridge. And that second cartridge, well, I don't carry it on the bottom of the taser. Oh, no, I don't do that. Because he's already seen photographs of the taser. No, I don't do that. What I do is I actually carry it on my belt. And then that way, you go in, there's a problem with the first cartridge, well, you can just go and get the second cartridge. That's what Lon Bartel told you. Except that he didn't have all the facts either. He never explained to you that even though he's double dipping out in Peoria, that even in Peoria, you don't leave the second cartridge back in the car. And that's another thing that the defendant does. He is in such a hurry. He wants to get to this for whatever reason. He wants to get at it so much that, well, I'll go in not quite fully prepared. Hurry. You can just see his attitude. Really wants to get at it. And guess what? Officer Regillo's already there. And he should be the person that is the primary, as they call it. He's been there longer as a police officer. Not only that, he got there first. But does that matter to the defendant? No, it does not. Because you can see him literally running, trying to get out of that car to be involved in this action. Not only did he not do the spark taser on his taser, which might or might not have told him that there was a problem with the taser. And when their expert says, oh, well, there was probably a probe there, and there was some wire that came out. If you remember, there's 22 feet, 9 inches worth of truth that Lon Bartel didn't tell you about. And so, you have this situation where this individual is out there ill-equipped. Not only is he ill-equipped with the taser, but he's ill-equipped mentally because he wants to get at it. You know he's ill-equipped mentally. He just can't wait to get at it. So we go over to trailer number 50. One of the things that happens is that the defendant begins to speak with the detective. And when she's talking to him, again, according to him, oh, she's so hysterical. She's so upset. Really? Did you hear the phone call? Which was approximately half hour before? Did she seem upset at that time to you? No? Then what makes you think that she would be more upset later as the event has passed on? No, you can use your ears and you can say, no, we've listened to that recording. She wasn't upset. But he wants you to think that she was upset because of what their own witness told you, what Catherine Black told you about his attitude. He needs her to be upset because he made the comment, you better speak English to me. I need to know what's going on. And he was rude about it. That's really committed service from an officer who can't even get his taser in working order, who is in such a hurry. But he needs her to be upset at that time. He needs her to be hysterical so then he can turn around and come in here and tell you, I couldn't understand her. I didn't even know what she was saying, and that's why I made the comment about her needing to speak English to me. Actually, you heard the point. You don't need for him to tell you whether or not she could be understood. She could be understood. It was just that he was in a hurry. Or at this particular point, he made the comment, for whatever reasons, they made that comment. It's just this attitude. After all, he's in South Phoenix. And in South Phoenix, that's one of the things that you think about, even though somebody speaks to you in English, that perhaps they better slow down and talk to you in English again. Well, at that point, before he gets going about his way, you got to take it. This attitude has to take another last-minute salvo. Just that's what he wants. Where he says, well, does your son speak English? Why would you even ask that question? The woman speaks English. Catherine Black speaks English. He was rude about it. That is not public service. And it goes to show you his attitude at the time. The attitude of this police officer was neglectful with regard to his commitment, was also neglectful with regard to the community. He had an agenda on that particular day when he was going to go over to Trailer 51. So bad he couldn't even wait. So bad he couldn't even wait for Sergio Virgilio. According to him, I'm not paying attention to where Sergio Virgilio is. The reason he isn't paying attention is because he can't wait to get at it. And this is the same individual that told you, oh, in the middle of all this, I was taking deep breaths so I could calm myself as I was going along. Does that sound to you like somebody that was calm? Does that sound to you like somebody that was taking deep breaths? Doesn't it? It was an individual who was in a hurry. He was in a hurry to get involved in whatever was going on in that trailer. Even though the complainant, his mother, at that point was calm. And there had been plenty of time that had passed before the incident inside the trailer, whatever it may have been, and the police coming out there. So he takes charge. He's like Alexander Haig or Ronald Reagan getting shot. I'm in charge here. Sweating. You can almost see that as he gets over to the door. He's answering it. Gee, you know, people, when they are in their houses, in the middle of the day, have a right to wash their hands, have a right to brush their teeth, and believe it or not, they even have a right to use the restroom. But nobody answers. He's got to go after him anyway. Wait a minute. His mother has just said, you know, she wants him there. But he's got to do more about it. He's got to get in there. Doesn't do the warrant route. No. It's easier to just go and talk to her. Isn't it interesting that initially when he talks to her, and he has a problem understanding her English, but when he wants consent, isn't it interesting that he has no problem understanding her English at that point? Isn't it interesting he doesn't have her sign something that says, yes, you know, just in case I didn't understand you, do you mind signing here saying that I have consent to go into this trailer that you may or may not own? Oh, he has no problem understanding that, but he certainly has a problem understanding her language skills earlier. And so, now armed with this consent that gives you the ability, gave him the ability to walk in, but it doesn't give his badge or his gun the right to abuse anybody in there. It gives him the right to go and look. It doesn't give him a right to come in like a cowboy and start putting the gun to somebody's head. He didn't go to talking. He didn't go to pepper spray. He didn't go to taser. He went straight for the gun as soon as he walked in by his own admission. And he is so at the ready. He is so at the ready to do something here. Guess what? Takes off. Starts walking. And when he's asked, well, what about Officer Virgilio? Richard Chrisman says, I don't know. I don't know where he is. I'm not paying attention to him. In that confined area, you saw how short the distance was between trailer number 50 and trailer number 51. Doesn't even know where Virgilio is. Doesn't even hear a phone call. Why? He's got that tunnel vision. He's already ready to go. He's amped up. He's not a reasonable officer at that time. He's ready to go. He doesn't even know where his cover is. And you know, if you don't know where your cover is and you're in there firing shots, tragic accidents happen that way. It's called friendly fire. But he's on his way. And he gets to that door. And when he's at that door, even though he has to stop and pause and knock according to him, he doesn't know where his cover is. And the reason he says that partly is because, well, he wants Officer Virgilio to be seen by you is somebody who's not doing his job, who is not there at the trailer with them. But wouldn't you expect that a reasonable officer, before he went knocking at a door, where according to him, he's seen this printout that says something about weapon violation, and then when he's asked about the date of 2003, or whatever the date was on there, well, he says, yeah, that involves an auto. But when questioned again, he said, well, maybe it wasn't an auto, maybe it was something else. He's somebody who's just creating this out of whole cloth for you, so that perhaps you can, once he does that, put it around you, and maybe around your eyes, so that you can't see what he's actually dishing out, or see what he's actually all about. But it's off, and he's at the door. And how long is he at the door? Must not be very long, because he's not looking for his partner, not even seeing his partner at that time. And as he stands there at that door, he says he knocks, and he announces in a very loud voice, well, the window to trailer 5150 is open. And Catherine Black is one of those people that is paying attention. Not only is she paying attention, but when the police are out there, most people just do pay attention. And she's listening for what may be going on. We don't know how loudly he did it, or announced himself. We know it wasn't loud enough for Catherine Black to hear it. For their own witness to hear this announcement. It's the police. You have to do it loud enough so that the people inside can come out. Give them a chance to come talk to you. You need to give them some time. You can't just go busting in. You got to give people time. And then this is a typical case where he should have waited. But he was in a hurry. He should have waited because actually, Mr. Rodriguez actually did come up. And so did the dogs when they heard something. So, goes to the door, opens it. Here comes the dogs. We have one dog who's a bigger dog who has cancer. A real big threat there, right? This dog coming at him? Yeah, this dog with cancer. Well, then there's another dog, a much younger dog. People have described it as a puppy. We have Junior coming. And one of the things that he does is he sort of then cracks the door open a little bit. He says he looks. And then he looks to see that this dog, Junior, goes back to Daniel Rodriguez, who's coming around the corner. That corner right there. You see there? And starts wagging his tail. That is a really dangerous dog that deserves to have a handgun pulled out and to be told, get back. That is a really dangerous dog. Especially when you now know from Catherine Black, again, there were witnesses that Junior is a puppy of a dog. Yes, looks like whatever it is that he thinks it is. Well, fine. It may look like that. But he's already seen indications that it is a friendly dog. And Catherine Black indicated to you, that is not an aggressive dog. It doesn't bark. I played with him. He's a friendly dog. So, but he wants you to believe him. He wants you to take his word for it. This person who's unprepared, this person who only has tunnel vision, and that tunnel vision could have affected how he viewed that dog. Because that tunnel vision that he has in his head says it's a mean dog, even though he's already seen indications to the contrary. A dog wagging his tail is a friendly dog. And the barking that may have been associated with it is so low, again, the neighbor didn't hear it. And you know that Catherine Black was paying attention to what was going on. When police come out there, you know, that's something that's exciting for people. It's like a wreck on the side of the freeway. People just want to look at it. And she was paying attention. Their own witness was paying attention. Didn't hear any dogs barking there. Didn't hear any screaming. Didn't hear any voices raised by Mr. Rodriguez. Well, he's got that tunnel vision going, and he's got that attitude. And when he goes in there, he does have a taser, and he does have some OC spray. But when he gets there, well, violated a little bit of what Lon Bartel told him. Because Lon Bartel talked about verbal judo first, where you talk to the person. Amazing how it could be that if you just talk to somebody as a human being, not a resident of South Phoenix, who you believe that because of the clothes that he's wearing, that somehow there's a problem here. If you talk to that individual according to their own witness, that's what you should do first. And when you talk to that person, maybe you'll get some responses back. And maybe that will take care of the situation. Huh? Here's the defendant's idea of discourse. We could send him over to the Palestinians and the Israelis. That's how good he is. He's so good that what is the first thing that he does? Well, when he is asked, and yes, Mr. Rodriguez did say, where is your fucking word? Or where is your motherfucking word? He did say that. There's no law against that. But the defendant responded more than in kind. But, you know, he can't remember. He can't remember anything that he said. He can remember anything anybody else said, but he can't remember what he said. You got to have faith. That is this lapse in memory. These lapses in memory that are so selective, you got to have faith that he doesn't mean anything by it. You just have to have faith that, you know what? That's how he's built. That he remembers everything everybody else says, but nothing that he remembers. Well, he went straight for it, and he responded more than in kind. He violated their own expert, Lombard tells you, of course, who said, well, try talking. And if talking doesn't work, well, maybe we can go further with hands-on. And after hands-on, well, you may have to use OC spray. Or after that, perhaps, or the pepper spray. Or after that, perhaps you can use a taser. He went ready to go. He went all the way to the gun. And again, he went to the gun because, as you know, he was, according to him, he was looking towards the dog. No, it wasn't anything about wanting to frighten Mr. Rodriguez. No. People don't get frightened when somebody in a blue police officer's outfit comes up to you and to your left temple puts that gun there. No, that doesn't put you in reasonable apprehension of physical injury. No, because he's an expert at guns, right? He's not going to pull the trigger, right? No, that's not going to startle anybody. No, that's what he wants you to believe. No, that was for the purpose of the dog. See, because these dogs in South Phoenix, they're quick learners, and they learn different things than those from maybe Scottsdale or North Phoenix, those dogs down in South Phoenix. Because if you get a gun out to those dogs down in South Phoenix and you wave it around, they recognize that. These hooligan dogs recognize that that's the authority that's vested in him. And they're going to back away, those darn dogs. That's exactly what he wants you to believe. This very non-aggressive dog. He wants you to believe that he understood the significance of the handgun. He's got an excuse. He doesn't want you to use your common sense. He wants you to have faith. Have faith. That's exactly what he wants you to do. Have faith in what he's telling you, not what your common sense tells you. He does admit that he takes that gun out. What happens with the dogs? Well, according to him, the dogs then back away. And so he reholsters his gun. Now, according to him, it can affect this detention. Now he can continue on with what he was really there, to lay hands. And oh, by the way, where's Officer Virgil? As you stand roughly where I'm standing now, I don't know. I don't have any idea where he is. He's supposed to be my cover officer, but you know, I've got this thing called tunnel vision, where all I can do is see this individual in front of me, and what I want to do to him, and me and my attitude. I mean, I have so much tunnel vision. I haven't even done the spark test on my taser. I got so much tunnel vision. That's all I can think of. But in the middle of that tunnel vision, I'm taking deep breaths. That's what he said to you. He's relaxing. Almost yoga that he's doing. That's what he wants you to believe. So which one is it? Doing yoga, or is he going after this individual like he told you in another part of his testimony? He's got to pick one. You can't be both ways. But he wants you to believe that you can. And oh, by the way, where's Officer Virgillo? Well, that officer, nowhere to be found. I don't even know where the heck he is. And according to the opening statement, he's out hiding in the bushes. Do you remember that comment? Any indication that he was out in the bushes? And if he is out in the bushes, how would he know if he's so focused here? How would he know where he was standing if he's not even looking at him? It could be that he's standing inches feet away from him, but because he's so focused, even knowing where he is, he can't tell you that he's able to see where he is. He can't tell you that he's paying attention to him. But by the same token, he can tell you he's out by the bushes. That's what he can tell you. Again, have faith. It's okay to take these kind of positions where they're in conflict. That's okay. I mean, you just have to have faith in him. After all, he almost cried up there on that witness stand. Did you see that? As soon as he took that witness stand, he grabbed that tissue and started rubbing it around his left finger. Did you see that? Oh, yeah. I mean, you got to have faith in somebody like that who's getting prepared for that big moment. You got to have faith in that. You got to at least do that. So he's inside of this trailer, and he has already escalated the situation so that when he's there, he needs to then do something, whatever it is that he's going to decide to do. But he starts doing it without the aid of Officer Virgilio. According to him, he doesn't see him anywhere, doesn't know where he is. He's going about it kind of like a cowboy, because he just wants to get at this guy. After all, look at this guy. This is somebody that he wants to take in. According to him, just by one look, you know, you can see that he's got that methamphetamine view about him. Well, this methamphetamine view that they told you was toxic. It was a toxic level that he took 16 hours before. Well, their own expert, Norm Way, the toxicologist, came in and said, that is not a toxic dose. That is not a toxic level. The amphetamine would be the same thing as if you were taking Adderall, the drug that is used for treatment people. That it was a therapeutic dose. And we understand that that's the metabolite. But the other one is just a normal sort of dose on those people that use it. I've seen it before. It is not toxic. Well, when that wasn't enough, when their own witness wouldn't agree with them, what do? Let's bring somebody in. Let's bring in Vincent DeMaio, who that's really not his expertise, because according to him, he sat in one class, they had a handout, and he read it to you. Well, anybody can go on the internet and do that. Anybody can go sit around and read something, and then they can come in and tell you, well, you know, just because I charge X amount of money, you have to believe me. No, you don't. The jury instructions tell you that you do not have to believe it. But they came in with two opinions now, because the first opinion that they gave you really didn't meet what they had told you previously, that it was a toxic dose. But he's now seen the eyes, and now he's seen the eyes, and he's now going to go hands up. Well, according to him, it's not his fault that Mr. Rodriguez was washing his hands, or he had water on him. It's not his fault at all. No. He went to grab, and what ended up happening is the hands kind of slipped away. But he was the aggressor. And what's clear here is that Mr. Rodriguez was never the aggressor. And what you take into account when you are deciding whether or not there is an issue of self-defense, you look at the conduct of the other individual. Have they, throughout this whole course of this incident, ever been aggressive? So that when something happens that you then shoot them, you don't just look at that particular instant. You look at everything that happened before to see what's actually going on, to decide what is actually going on. And in this case, what's actually going on is the only person that's the aggressor is the defendant. Mr. Rodriguez never, according to his own admission, but again, he forgot. With the truth, you can't remember all these things. By his own admission, Mr. Rodriguez was never the aggressor. Just kept backing away, going down to where the hallway was, trying to raise his hand. Even when he had the gun up to his temple, Mr. Rodriguez didn't even slap it back, didn't even do anything. He just was never the aggressor in this situation. And as a police officer, or as a reasonable person, a reasonable police officer, you are required to take that into account. And by his own admission, Mr. Rodriguez was never aggressive throughout this whole encounter. Didn't want to get arrested. Didn't want to be taken outside initially, but was not the aggressor. And can you almost blame Mr. Rodriguez for not wanting to go outside? If somebody has already put the gun to his head, is starting to grab him, and you, at that point, then that makes somebody a little angry, saying, well, I really don't want to go with you. Why should I go with you? You've already done that to me. What are you going to do to me out there that you aren't doing to me in here? So he goes to grab him, and by his view of events, now he's trying to be the reasonable police officer. He's now going to use the continuum. Even though he's already leapfrogged all the way to taking the gun out, let's hit the reset button. Let's hit the reset button, and now I'm going to be the reasonable police officer. And because I have hit the reset button. And where's Officer Virgilio? I don't know. I don't really care. Because I want to go after this guy. Given his attitude toward his equipment, given his attitude the way he arrived there, given his attitude toward the job, given his attitude to the community, this person was just out to get this guy. He was just out to get him for no reason. That's what he was doing. Yes, there had been a complaint, but why don't you at least try talking to the guy instead of pointing the gun to his head? No, just gonna go hands-on. Goes hands-on, and not that he's not strong enough, but it's because of the water. And so Mr. Rodriguez starts to move away. Well, he decides that maybe it's time for that pepper spray to come into play. And lo and behold, there he is. Officer Virgilio's there. And the only reason that he says he's there is to cast aspersions on Officer Virgilio. The only reason he acknowledges he's there is to say he's a bad officer. He didn't stick with me when I got that pepper spray on him. And if you remember, one of the things that happened here in court was when the items were being opened, and this is something that you can take a look at. At one point, Judge Bramble even indicated something about the pepper spray getting to him after all this time. So when he starts to cast aspersions, asked Officer Virgilio, really? He can't have a reaction to this pepper spray? Remember? Of course he can have a reaction to this pepper spray. And since they're standing right here, the way he portrayed it, he makes it seem like he walked way out of the way, so that he was so far away so that he was leaving him behind. But according to him, that'll happen right here. So if Officer Virgilio takes 1 or 2 steps back, he's still in the vicinity. But he wants you to remember that. He doesn't want you to consider that. He wants you to think that Officer Virgilio is not there to cover it. When it's to his benefit to cast aspersions, yes, there is Officer Virgilio that is there. But when it's going to hurt his case, oh, I don't know where Officer Virgilio is. He's not there to help me at all. He's not somebody that I can rely on. Perhaps if you were to look to your left instead of being such tunnel vision, or perhaps if you took a couple of seconds away from doing these deep breathing exercises, you would be able to see him. And, oh, by the way, when you're doing these deep breathing exercises, you could have reached for the button and called 906. You could have called for a backup. But no, don't think about that. I can have plenty of time to sit back, be calculating, and think about things, but I didn't have time to get on the radio. Well, which is it? Do you have time to be sitting there, breathing? Do you have time to then also be looking at this person? Do you also have, but you don't have time to look to see where Officer Virgilio is, and you don't have time to call for a 906 when this individual doesn't want to go with you. Well, after this pepper spray, they try this hands-on thing again. It doesn't work. True. Here's it. Mr. Rodriguez doesn't want to go. And so the defendant begins to escalate. He takes out his taser, this taser that he has not tested that day. And the reason that that's important, you're going to say, well, what difference does it make? Well, they rely on the taser and the manufacturer to tell you, well, it doesn't work on animals. They have a built-in excuse that it doesn't work on animals. That's why it didn't matter if he didn't have this other cartridge. And so, it doesn't matter that he doesn't have this other cartridge available to use on the animal. Really? Dominic Barrios attended the same training that the defendant attended. And when he attended that training, lo and behold, at the Phoenix Police Department, and he was with the Phoenix Police Department, they do tell you that it's effective against dogs. They even tell you to go sideways so that when you shoot, you can get the whole body of the dog. Well, is he the same unprepared officer that perhaps slept with that? He says, oh, I don't remember. not remembering is as bad as bringing somebody in here to say that that's not the truth, that you can't use it against animals. They want you to believe that as part of his knowledge, he couldn't have used that taser on the dog. And they bring in somebody from Peoria to tell you, no, it can't be used on dogs. When that person doesn't even know the training that this individual received. The training that tells them that it is effective on dogs. But he'd better use the gun than the taser. And Judge thinks that's a break.
All right, ladies and gentlemen, we had asked Mr. Martinez to find a logical break so that we can take the lunch break. We are going to take the lunch recess this time. Please remember the admonition, keep an open mind, don't discuss the case. We'll see everybody at 1:30. Jurors are excused.